sometimes, to really get a handle on where things are now, you kind of have to go back, way back, especially into these foundational legal documents, the ones that really shape nations. And today, that's exactly what we're doing. We're diving into the Government of India Act, 1935.
Yeah, a big one.
We've got a pile of sources here, mostly excerpts pulled straight from the act. And, well, looking at it, it's dense.
Oh, definitely. Legal jargon galore.
A bit intimidating, honestly. But buried in there, you find these crucial details. They explain so much about a massive turning point for India.
Absolutely. And that's our mission with this deep dive, right? To unpack this really monumental piece of law.
Yeah.
We'll try to cut through all that legalese together, find the really important bits, understand the structure it was trying to create.
Trying being the operative word sometime.
Well, yes, and see what it tells us about that, well, incredibly ambitious attempt to completely reshape how India was governed back in the mid-30s.
Exactly. So think of this as your shortcut. We're digging out the surprising bits, the core mechanics, the stuff that makes you go, ah, okay. So you get the gist without spending weeks buried in hundreds of pages yourself. Okay, let's unpack this thing.
Okay, so setting the scene, the really foundational idea, the big vision behind the 1935 Act was to create something called the Federation of India.
A federation, right.
And this was huge, hugely ambitious. It wasn't just about British India, the bits directly run by the Crown. It was also trying to bring in all those semi-independent princely states. Hundreds of them.
Wow.
And to build this federation, the act laid out a specific government structure. You'd have a governor general at the top, the federal level.
Appointed by the king.
Appointed directly by His Majesty, yes.
Yeah.
And then each province would have its own governor, also appointed by the king.
Now, that bit about the princely stakes, that's fascinating. They weren't just automatically roped in, were they?
No, not at all. The plan was for them to join using these things called instruments of accession.
Instruments of accession. Okay.
So each ruler, each prince, was supposed to sign one. And this document, crucially, would spell out exactly which subjects the new federal legislature could make laws about for that specific state.
So they could pick and choose, sort of?
Pretty much. And they could also list limitations on federal power within their borders. So it really highlights that their joining was supposed to be voluntary, negotiated, not forced.
Which, yeah, as history tells us, became a major sticking point.
The huge one. Okay, so moving inside that proposed federation, the federal executive, the sources show it centered squarely on the governor general.
The king's appointee.
Exactly. He chose his ministers, summoned them, and importantly, they served during his pleasure, meaning he could fire them.
Ah. Okay, so not quite like a cabinet responsible to a parliament in the way we might think of it now.
Not entirely, no. And legally, all federal executive actions had to be formally done in the governor general's name.
And his powers, you mentioned, they were significant.
Oh, very. The act specifically carves out areas where he could act in his discretion or exercise his individual judgment. This is a really key theme.
Okay, what's the difference? Discretion versus individual judgment.
Good question. Discretion basically meant he didn't even have to ask his ministers for advice. He could just decide.
Right.
Individual judgment meant he had to listen to their advice, but he could then ignore it and do what he thought was best.
Wow. Okay, so huge scope for him to act independently of any elected Indian minister.
Absolutely. These were powerful tools. And on top of that, the act says he was under the general control of the Secretary of State for India back in London. Another layer.
Got it. Okay, what about the legislature? The lawmaking part.
So the federal legislature, according to the sources, was planned to be bicameral, two houses.
Like the UK Parliament?
Sort of, yeah. A council of state, the upper house, and a federal assembly. The act laid out, the basic rules for who could be a member.
Yeah.
Generally, a British subject or someone from an acceding state.
Any age?
Yep. 30 for the council of state, 25 for the federal assembly.
And how were seats divided up? That must have been complicated, trying to represent British India and the states.
Extremely. The sources have these detailed tables. For British India, seats were allocated by category. You had general seats, but also specific numbers for Sikhs, for Muslims, for women. For scheduled castes, they called them depressed classes then.
Right.
And even for special interests like commerce and industry and labor, it reflected the complex social map.
And the states?
They got their own block of seats, too, allocated based on population or importance, often grouped together. It really underlined their separate status within the federation idea. Now, Who gets to make laws about what? The Act used these lists. I was a federal legislative list, stuff only the Federation could legislate on.
Okay, so the big national things.
Exactly. Think currency, coinage, managing public debt, posts and telegraphs, and yeah, interestingly, broadcasting was already in there.
Even then?
Even then. Also,
Right.
railways, major ports, shipping, aviation, banking, insurance corporations.
Yeah. So the main economic and administrative infrastructure.
Pretty much. Plus, major taxes like customs duties and income tax, except agricultural income tax, that was kept separate.
Okay, but were there limits on what this federal legislature could do? It sounds powerful.
There were definitely checks. Some types of bills couldn't even be introduced without the Governor General signing off first.
That discretion again?
Yep. And remember the instruments of accession. The feds couldn't legislate for a state beyond what that state had agreed to.
Right, the negotiated limits.
Exactly. Plus, the Governor General, using his special responsibility for peace and tranquility, could literally order the legislature to stop debating a bill if he thought it was dangerous.
Wow. Okay, so significant power, but with significant checks held by the Governor General.
Precisely. Now let's shift down a level. Provincial autonomy. This is another major feature of the Act.
Giving more power to the provinces.
That was the idea. Each province got a governor, again, appointed by the king, and surprise, surprise.
Let me guess, discretion and individual judgment.
You got it. Governors also had areas where they could act on their own, bypassing their provincial ministers. The sources mention things like police rules always sensitive or dealing with terrorism or political violence.
So autonomy, but qualified autonomy.
Very much so. The governor held ultimate cards.
What did the provincial legislatures look like?
It varied. The bigger provinces, Madras, Bombay, Bengal, UP, Bihar, Assam, were sent to have two chambers, a legislative council and a legislative assembly.
And the others?
Just one chamber, the legislative assembly. Each house had a speaker or a president to preside, and they got a casting vote if there was a tie. Standard parliamentary procedure, pretty much.
Who could be a member? Similar rules to the federal level.
Broadly, yes. Qualifications often involved residency. Disqualifications were things like holding a government job, an office of profit, being declared bankrupt or of unsound mind, or having serious criminal convictions, or being found guilty of election corruption.
Makes sense.
And the Act actually spelled out penalties if you sat and voted knowing you were disqualified.
One thing that jumped out at me from the sources was the mention of freedom of speech within the provincial legislatures.
Yes, that's significant. Members were explicitly protected from being sued in court for anything they said or any vote they cast during legislative proceedings.
A key parliamentary privilege.
Absolutely. Essential for robust debate, in theory.
Okay, so what powers did these provincial legislatures get? There must have been another list.
Yep. List 2, the provincial legislative list. And this covered a lot of ground, really impacting daily life.
Like what?
Police, including railway police and village police, prisons, public health, sanitation, education.
So core local services.
Right. Local roads, bridges, ferries, even minor railways and local tramways, inland waterways, local government itself, land revenue collection.
Taxes, too.
Yes, crucially, taxes on agricultural income. Remember, the feds couldn't touch that. Also, taxes on land and buildings, professions, trades, even sales taxes and local entry taxes, cessuses.
So quite a bit of power devolved compared to before.
Definitely. On paper, it looked like a significant shift towards provincial self-government.
But you've got list 1 for the feds, list 2 for the provinces. What if they clash? What if a provincial law contradicted a federal one?
The Act was clear. If a provincial law was repugnant, meaning it clashed with a federal law on a subject where the Federation also had the power to legislate, there was actually a third list, a concurrent list we haven't even got to, then the provincial law was void.
Federal law wins.
Federal law prevails. Though there was a quirky mechanism. The federal legislature could make laws on a purely provincial subject if 2 or more provinces actually asked it to by passing resolutions in their legislatures.
Interesting. A way for provinces to cooperate or seek central help, maybe.
Possibly, yeah. Now, beyond just dividing powers, the Act dealt with areas needing coordination. Finance is a big one.
How did the money work?
It was complex. Certain taxes were actually levied and collected by the Federation, the central government. But the money collected, the proceeds, were then supposed to be distributed, wholly or partly, back to the provinces and any states that joined.
Which taxes were those?
Things like income tax on non-agricultural income, succession duties, certain taxes on transport like railway fares, or freight. The exact sharing formula was up to the federal legislature to decide.
And could the Federation keep anything extra for itself?
Yes, it could slap on federal surcharges on top of those shared taxes, and all the surcharge money went straight to the Federation's budget.
Oh, okay.
Plus, there was provision for grants and aid. Basically, central funding given to provinces that the king, advised by his government, decided were in financial need.
How was all this spending approved? Did the legislatures get a say?
Yes and no. Budget estimates, the demands for grants, had to be presented to the legislature's Federal Assembly first, then Council of State federally, the Legislative Assembly provincially. They could vote on these demands.
I sense a but.
There's always a but. Certain expenditures were charged on the revenues. This meant they had to be paid. The legislature couldn't vote them down.
Like what?
Things like the salaries and pensions of federal court judges, debt charges, defense spending, costs related to foreign affairs or the crown's dealings with the princely states. Basically, key sovereign functions and obligations were kept out of the legislature's direct financial control.
Got it. What about the people running the show? The civil servants?
The services of the crown, as the act called them. It set up separate federal and provincial public services.
Who hired them? Set their pay?
Recruitment pay conditions that was generally managed by the Governor General or the relevant governor. For the top jobs, especially the Indian civil service, appointments and rules often still came directly from the Secretary of State in London.
And those public service commissions?
Yes. The act mandated them at both federal and provincial levels. Their main job was to conduct exams for recruitment, ensuring some level of meritocracy, and advise on service matters. The act also had special provisions for judges and even chaplains.
Now, there's a section in the sources, Part 6, about discrimination. That sounds potentially quite loaded.
It is, and it's very revealing. It had a general clause saying British subjects from the UK or India couldn't be discriminated against based on religion, birthplace, descent, or color for government jobs or running businesses in British India.
Okay, sounds good so far.
But this protection didn't apply if similar discrimination existed in the UK against British subjects from India.
Wow. So a sort of, we won't discriminate against you here unless you discriminate against our people back home clause.
Essentially, yes. It wasn't a universal principle. It was conditional and reciprocal, tied to treatment in Britain. And beyond that general clause, there were very specific protections just for British subjects domiciled in the UK.
Protecting British interests in India.
Clearly. Things like ensuring they weren't taxed more heavily than Indians, guaranteeing rights for British companies, British shipping, even British doctors wanting to practice in India. There was even a right of appeal to the Privy Council in London for doctors in certain disputes. It shows that tension, again, granting some rights while very carefully protecting established British interests.
That's fascinatingly complex.
Mm-hmm.
What other specific areas did the Act cover?
Water supplies. Hugely important, especially for agriculture. The Act set up ways to handle complaints about one province or state interfering with another's water supply.
Through the courts?
No, interestingly, the Act specifically excluded the courts from having jurisdiction over these water disputes. It was meant to be handled administratively or politically.
Keeping it out of legal battles. Sensible, maybe?
Perhaps. And for cooperation, the sources mention the Governor General could set up an interprovincial council if he thought it was needed.
A forum for provinces to talk to each other.
Exactly. To discuss common issues, coordinate policies.
What about broadcasting? You mentioned it was federal.
Mostly, yes. Federal control generally. But the Act allowed the Federation to delegate broadcasting functions to provinces or states.
Could they control the content then?
No. The conditions the Federation imposed couldn't be used to regulate the content of what the province or state broadcast. An interesting distinction.
And railways. That
Yeah.
must have been crucial.
Absolutely critical. The Act treated them very specifically. Executive power over railways wasn't with the regular federal government. It was vested in a separate Federal Railway Authority.
Who ran that?
Its members, including the president, were appointed by the Governor General acting in his discretion. Another key area kept under direct British control.
And its finances.
It had a complex relationship with the main federal budget. It also had obligations like paying provinces for the police needed on railway property. And if there were disputes about traffic or rates, they went to a special railway tribunal, not the regular courts.
So railways were almost a government within a government.
In some ways, yes, reflecting their immense strategic and economic importance. Okay, let's maybe try and pull some threads together. We keep coming back to those powers of the governor general and the governors.
The discretion and individual judgment.
Exactly. These weren't just minor details tucked away. They were fundamental. They were the built-in checks, the ultimate controls on how much responsible government Indian ministers actually had, both federally and provincially.
The safety brakes for the empire, essentially.
You could certainly see it that way. And speaking of safety brakes, the sources detail the ultimate one: the failure of constitutional machinery provisions.
What did that allow?
It meant a governor, if he decided the provincial government just couldn't function according to the act, could issue a proclamation.
Taking over.
Pretty much. He could assume all governmental functions himself, acting in his discretion, suspend the legislature, rule directly.
How long could that last?
Initially 6 months, but the British Parliament could extend it potentially up to 3 years. And a similar power existed for the Governor General at the federal level, though the sources suggest there were some complications there related to the princely states potentially not having joined after 3 years. But the basic idea was the same. If things broke down, the British appointed head could suspend the whole constitutional setup.
A very powerful emergency measure.
Extremely. Okay, let's talk judiciary. The act set up a new federal court.
The top court for India.
Sort of. Judges appointed by the king, serving until age 65. They could be removed, but only by the king after a report from the Privy Council in London.
High bar for removal?
Yes. Qualifications involved experience as a high court judge or a senior lawyer. The Chief Justice needed even more seniority.
What kind of cases did it hear?
Its main original job was settling disputes between governments, federation versus province, province versus state, and so on. Though, importantly, it generally couldn't rule on disputes about agreements made before the federation started unless the agreement itself said the court could.
What about appeals from lower courts?
That was more limited than you might think. It couldn't, for instance, hear appeals from high courts about cases originating in courts outside British India, like in the princely states. And appeals from British Indian high courts could still sometimes go directly to the Privy Council in London, bypassing the federal court.
So not quite the Supreme Court in all matters.
Not automatically, no, though the federal legislature could potentially give it more appellate power, but bills doing that needed the Governor General's prior approval. Another check. And below the federal court were the high courts in British India. The act basically confirmed the status of existing high courts.
Judges appointed by the king.
Yes, salaries and pensions fixed by the king, too. The Governor General could appoint temporary judges if needed. One detail initially, high courts couldn't hear original cases about government revenue disputes.
Okay. And finally, how do they plan to actually get this massive act up and running? It couldn't happen overnight.
No, and the act acknowledged that. Part 13 contained transitional provisions. This was all about managing the changeover period before the full federation was supposed to start, which, of course, never fully did in the way planned.
What did these provisions cover?
Things like letting existing laws and government rules continue temporarily, as long as they weren't totally contradictory to the new act, how the central government would run before the federation was formally proclaimed. It also explicitly confirmed the Secretary of State's ongoing control over the Governor General during this transition, especially regarding spending. It even mentioned managing existing government loans raised in London.
So basically bridging the gap from the old system to the new one.
Exactly. The act itself admitted difficulties were likely. It was a practical necessity.
Wow. Okay, so we've covered a huge amount of ground there, digging into the Government of India Act 1935. That vision, ambitious but flawed maybe, of a federation. The really complex split of powers between the center and the provinces.
Yeah.
The huge authority kept back by the Governor General and governors.
The discretion, yeah.
All the detailed rules for money, for the civil service, the judiciary, railways, even things like water rights and those tricky discrimination clauses. It's incredibly intricate.
It really is. And I think what stands out is how it tried to do two things at once, almost contradictorily. It introduced more Indian participation, especially in the provinces, a step towards responsible government.
Right.
But at the same time, it built in these incredibly strong checks and balances, the discretionary powers, the way the federal executive worked, the limited buy-in from the states, all ensuring that ultimate control stayed firmly in British hands. It's a fascinating snapshot of that political tension.
And understanding this document, even though it was eventually superseded, feels crucial. It's not just history. it shaped the whole debate leading up to independence.
Absolutely. Concepts like the division of powers, provincial autonomy, these ideas didn't just vanish. They were debated, adapted, argued over, right into the framing of India's own constitution later on.
So it laid down tracks that later paths followed or deviated from.
Exactly. And maybe zooming out, this act is more than just a law. It's an incredible example of constitutional engineering, but also maybe a case study in the sheer difficulty of transferring power gradually, or perhaps partially. Given how complex it was, how many limits were placed on Indian ministers, how conditional the whole thing felt, especially with the states, it makes you wonder, doesn't it? What does this incredibly detailed framework tell us about the challenge of trying to grant self-governance while still wanting to hold on to ultimate imperial control?
Yeah.
It forces you to think about how these foundational legal texts, they aren't just abstract principles, they're often very pragmatic, maybe even political responses shaped by the specific power dynamics and pressures of their day.